Before we get started, please remember that this video is for informational and entertainment purposes only and does not constitute legal advice. The world of law is incredibly nuanced and specific to the facts of each situation. If you require legal assistance, it is essential that you consult with a qualified attorney licensed to practice in your jurisdiction. A first-year lawyer straight out of law school can walk into a New York City law firm and make more than $250,000 in their first 12 months. $225,000 in base salary, plus a bonus that can easily push them over $250,000. That's more than most doctors make after a decade of training and residency. It's a staggering, life-changing amount of money. And here's the part they don't tell you in the glossy recruiting brochures. Nearly half of those bright-eyed, top-of-their-class lawyers will be gone within 3 years. Burned out, chewed up, and spit out by the very machine that promised them the world. They don't just leave the firm. Many of them leave the law entirely. So what happens in those 3 years? What is it about practicing law on that tiny island of Manhattan that makes it a fundamentally different universe from practicing law in Chicago, or Los Angeles, or Dallas? It's not just that the buildings are taller or the coffee is more expensive. The very DNA of the legal work is different. The pressure is different. The stakes are on another planet. If you're a law student dreaming of that skyline view, a lawyer in another city wondering if you should make the leap, or even just someone fascinated by the real-life world behind shows like Suits, you're in the right place. We are about to pull back the curtain on the 5 core pillars that make New York City the undisputed, heavyweight champion of the legal world, and one of the most brutal professional environments on earth. We're going to break down the money, the global stage, the cutthroat culture, the warp-speed pace, and the insane level of specialization that defines this legal ecosystem. And by the end, you won't just understand that it's different. You'll understand why. To get it, you have to start with the money. Not the salary the lawyers are paid, but the money that flows through the city itself. New York City is not just another American city. It is, for all intents and purposes, the financial capital of the world. Wall Street isn't just a street, it's a global engine. And the high-powered law firms in Midtown and downtown Manhattan are not just participants in that engine. They are the architects, the mechanics, and the emergency surgeons who keep it running. Think about it this way. A big company in, say, Cleveland might need a law firm to handle a $10 million factory acquisition. That's a huge deal for that city. The best lawyers in Ohio will be on that case. In New York, a $10 million deal is a rounding error. It's a Tuesday. The clients for top New York firms are not just companies. They are the titans of global finance. They are the investment banks, the private equity behemoths, the hedge funds, and the sovereign wealth funds that move not millions but billions, and sometimes trillions of dollars in a single transaction. When a private equity firm decides to buy a publicly traded company for $60 billion in a leveraged buyout, who do you think structures that deal? Who navigates the labyrinth of securities regulations, antitrust laws, and international tax codes? It's an army of New York lawyers. Hundreds of them, from senior partners billing at $2,000 an hour to junior associates billing at $500, all working around the clock in a data room for weeks on end. The legal fee for a transaction like that could easily be $50, $60, even $100 million. And to the client, it's worth every single penny. Because a single mistake, one misplaced comma in a 100-page credit agreement, could cost them $1 billion. This is the first fundamental difference. The scale of the financial stakes. It creates a concept that barely exists in most other cities. Bet the company litigation. If your entire $70 billion corporation is on the line because of a hostile takeover attempt or a massive federal investigation, you don't go looking for the most affordable lawyer. You don't shop around for a good deal. You go to New York and you hire the legal equivalent of the Navy SEALs. You pay them whatever they ask because the cost of losing is extinction. This financial reality completely reshapes the lawyer-client relationship. In most of the country, a client might question a legal bill. They'll ask why 4 lawyers attended a meeting or why research took 20 hours. In the upper echelons of New York law, the dynamic is flipped. The client isn't just paying for an outcome. They're paying for absolute certainty and overwhelming force. They're paying for a firm that can throw 300 lawyers onto a problem overnight. They're paying for the firm's reputation, which can itself intimidate the other side into settling. The bill is secondary. The only thing that matters is winning. And this immense pressure, this fire hose of global capital, flows downhill directly onto the head of that 25-year-old first-year associate. When the client is paying your firm $1,000 an hour for your partner's time, they expect perfection. And they expect that same level of obsessive, relentless perfection from you, the junior associate who is reviewing 10,000 documents at 3 a.m. on a Saturday. You are not just a lawyer. You are a component in a multi-million-dollar machine built for one purpose: to serve the needs of global capital. That's why the burnout is so staggering. It's not just the hours. Lawyers work long hours everywhere. It's the sustained intensity. It's the knowledge that there is zero margin for error. A typo in a local contract in another city might be embarrassing. A typo in a bond indenture filed with the SEC could trigger a default and vaporize hundreds of millions of dollars. You're not just proofreading a document. You're diffusing a bomb. Day after day. For years. The $250,000 salary isn't a prize. It's combat pay. It's a retention tool designed to keep you chained to your desk, while every rational instinct in your body is screaming at you to run. It's the golden handcuff. And this relentless financial engine is just the beginning. It's the foundation upon which everything else is built. Because when the money is this big, it doesn't just attract the best legal minds from across the country. It attracts the biggest problems from around the entire globe. And these aren't your typical corporate disputes. We're talking about sovereign debt crises where a nation's future hangs in the balance, adjudicated not in The Hague, but in the Southern District of New York. We're talking about $100 billion mergers between multinational conglomerates from different continents, where a single regulatory snag in the US can scuttle the entire deal. This is where a Russian oligarch, sanctioned by the West, hires a team on Park Avenue to fight for his frozen assets. It's where a Brazilian state-owned oil company, facing a massive corruption scandal, has its international bonds traded and litigated on Wall Street. New York isn't just a city. It's the world's legal battleground. It's the neutral territory, the Switzerland with skyscrapers, where the planet's most powerful entities come to settle their scores. And for a young lawyer, fresh out of law school, this is the gauntlet. You arrive, diploma in hand, thinking you're at the top of your game. You graduated with honors, you were on law review, you beat out thousands of applicants for this job. You feel invincible. And on your first day, you're handed a stack of documents, or more likely, given access to a virtual data room. And you realize you know absolutely nothing, because the scale is simply incomprehensible. Imagine a corporate lawyer in Cleveland or Phoenix. A big case for them, a bet the company litigation, might involve 50,000 documents to review. That's a mountain of work. In New York, for a junior associate on a major international case, 50,000 documents is what you're expected to get through by lunch. The starting point for a moderately complex case is often 5, 10, 20 million documents. Emails, contracts, text messages, internal memos, spreadsheets, a digital ghost of a global corporation. And your job, as the lowest person on the totem pole, is to be the first line of defense. You are the digital archaeologist, sifting through the rubble of a corporate disaster, looking for the one shard of evidence that can win or lose a billion-dollar case. There's a persistent myth that junior associates are just expensive copy machines, that they do mindless, repetitive work. And while the work can be grueling, it is never mindless, because the stakes are too high. A single misplaced comma in a debt covenant agreement worth $5 billion can trigger a default. A single hot email that you missed during a review, an executive saying let's bury the bad results, can lead to sanctions, criminal charges, and front-page headlines on the Wall Street Journal. The pressure is immense. You are 26 years old, running on 3 hours of sleep and a steady 4 drip of coffee, and the fate of a Fortune 500 company could genuinely rest on your ability to stay focused at 3 in the morning. You learn to see the world differently. You're not reading for comprehension. You're hunting for keywords, for concepts, for anomalies. You develop a sixth sense for the language of corporate concealment. The overly casual email from a CEO. The sudden switch from corporate email to a personal Gmail account. The gap in a document production log. These are the tells. This is the game. You're not just a lawyer. You're a detective, a codebreaker, and a psychologist, all rolled into one. And your only tools are a search engine and a crushing sense of responsibility. And then there's the speed. People talk about a New York minute as a joke. In New York law, it's a business model. The entire ecosystem operates at a velocity that is simply unsustainable in other markets. A partner can walk by your office at 6 p.m. on a Friday and say, "The client in Tokyo is furious. They just got served with a temporary restraining order. I need a full brief in opposition, with supporting affidavits, filed by market open in New York on Monday." Your entire weekend, any plans you had, any semblance of a personal life, vanishes in that single sentence. It's not a request. It's a statement of fact about what the next 48 hours of your life will be. In another city, a lawyer might get a week, maybe 2 for that same task. There would be meetings, strategy sessions, a chance to delegate and plan. In New York, the planning happens in the elevator ride down to grab a stale sandwich from the 24-hour deli. The strategy is get it done. This relentless pace is driven by 2 things: the clients and the courts. The clients are paying astronomical fees, often upwards of $2,000 an hour for a senior partner, and they expect immediate, 24/7 service. They don't care that it's your anniversary or that you have the flu. Their problem is now your problem. The courts, especially the federal courts in the southern and eastern districts of New York, are famous for their rocket dockets. The judges are some of the sharpest legal minds in the country, and they have zero patience for delay or inefficiency. They are juggling cases that involve international terrorism financing, complex securities fraud, and landmark intellectual property rights. They expect lawyers to be prepared, to be concise, and to be ready to argue a motion at a moment's notice. Asking a New York federal judge for an extension because you're busy is like telling a drill sergeant you need a nap. It will not end well. This environment creates a unique and brutal form of natural selection. It's called up or out. There is no coasting in a top New York law firm. You are constantly being evaluated, ranked, and measured against your peers. Every assignment is a test. Every interaction with a partner is a job interview. You either demonstrate the intelligence, the stamina, and the raw ambition to climb the ladder towards partnership, or you are gently, or not so gently, counseled out. The firm helps you find a nice in-house job at a bank, or a government position, or a spot at a smaller firm in another city. It's a polite, professional form of exile. This system has a profound psychological effect. It forces you to build a kind of armor. You learn to absorb devastating criticism from a partner without flinching. You learn to project absolute confidence to a client, even when you're riddled with self-doubt. You learn to compartmentalize, to wall off the stress and the anxiety just to get through the day. Your entire personality begins to warp around the demands of the job. Your communication becomes more direct, more efficient. Your analysis of any situation, personal or professional, becomes a risk assessment. You start to see the world not in shades of gray, but in terms of leverage, liability, and potential outcomes. It's an isolating experience. Your friends from college who work 9-to-5 jobs in other fields simply cannot comprehend your reality. They don't understand why you can't make it to a birthday dinner, why you're always checking your phone, why you sound so tired all the time. You exist in a bubble, a high-stakes ecosystem populated only by other people living the exact same frantic life. Your colleagues become your closest confidants and your fiercest rivals, often at the same time. But this intense pressure cooker doesn't just forge lawyers. It forges a very specific kind of legal system, with its own unwritten rules, its own unique judicial personalities, and a courtroom culture that would be completely alien to a lawyer from anywhere else in the country. Because in New York, the fight doesn't just happen in the boardroom or over email at 3 a.m. It culminates in the courtroom. And the judges in New York, well, they're a different breed entirely. Imagine you're a third-year associate from a respectable firm in, say, Denver or Phoenix. You're sharp, you've won some motions, you know your way around a courtroom. You feel confident. Then, your firm partners with a New York office on a massive case, and you get sent to handle a routine status conference at 60 Center Street, the home of the New York County Supreme Court. You walk into a courtroom that feels like it was carved out of marble in history a century ago. It's imposing. The judge, a woman with a reputation that precedes her, sweeps in, sits down, and doesn't even look up from the mountain of paperwork on her desk. She just says your case number, not the name, the number. You step up to the lectern, heart pounding a little faster than usual, and you begin your carefully prepared opening. Good morning, Your Honor. For the record, my name is... Before you can finish your sentence, she cuts you off, her eyes still glued to the page. I've read your brief, counsel. All 40 pages of it. I also read your opponent's brief. And I've read the last 3 motions you both filed. Tell me, in one sentence, why I shouldn't grant their motion for summary judgment and throw your case out right now. You have 10 seconds. Silence. The air gets sucked out of the room. Your perfectly crafted arguments, your talking points, they all evaporate. 10 seconds. This isn't a hearing. It's a firing squad. And that, right there, is your introduction to the New York judiciary. It's not about pleasantries. It's not about long, winding arguments. It is a relentless, high-speed pursuit of the core issue. The judges in New York, particularly in the state and federal courts that handle major commercial litigation, are operating on a completely different plane of existence. The sheer volume of cases they handle is staggering. A judge in a smaller jurisdiction might have a few dozen complex cases on their docket. A judge in Manhattan's commercial division is juggling hundreds, each with millions if not billions of dollars on the line. They don't have time for fluff. They don't have patience for unpreparedness. They have read everything, and they often know your case better than you do. They've spotted the weakness in your argument on page 37, footnote 12, and that's the first thing they're going to ask you about. They are masters of the Socratic method, not as a teaching tool, but as a surgical instrument to dissect your case in front of a live audience. An unprepared lawyer in a New York courtroom isn't just embarrassed. They are professionally dismantled. The goal isn't to be cruel. The goal is to be brutally efficient. In a city where time is literally money, judicial time is the most expensive currency of all, and they will not allow you to waste a single second of it. This environment is supercharged by something unique to New York: the Commercial Division of the Supreme Court. This is a special court established in 1995 specifically to handle the most complex, high-stakes business disputes in the world. Think of it as the legal equivalent of the Navy SEALs. The judges assigned to this division are often former titans of the private sector, lawyers who spent decades litigating the very same multi-billion-dollar contract disputes and corporate breakups they now preside over. This creates a dynamic that is unheard of in most other places. You aren't just arguing in front of a judge, you're arguing in front of an expert. You can't get away with a surface-level understanding of a complex financial instrument or a convoluted merger agreement. The judge knows what a collateralized debt obligation is. The judge understands the nuances of international arbitration clauses. They have seen every trick, every delay tactic, every flimsy argument in the book, because they probably used them themselves 20 years ago. This expertise means they demand a level of sophistication from the lawyers that is off the charts. Your legal briefs can't just be well written. They have to be academic in their rigor but brutally concise in their delivery. Your oral arguments can't be a speech. They have to be a high-level conversation with an intellectual peer who is constantly stress-testing your logic. It forces New York litigators to be more than just lawyers. They have to be business strategists, financial analysts, and master communicators all rolled into one. You learn very quickly that the judge is not a passive referee waiting for you to make your case. They are an active and often aggressive participant in the process. Then there's the federal court, the legendary Southern District of New York, or SDNY. This is the courthouse that has handled the most significant white-collar crime and securities fraud cases in American history. From the prosecution of Wall Street titans to landmark terrorism trials, the judges of the SDNY are renowned for their intellect and their no-nonsense approach. Appearing in the Southern District is a rite of passage, and it's one that instills a unique kind of fear and respect in lawyers. The standards are impossibly high. The local rules are intricate and unforgiving. A missed deadline or a formatting error in a brief that might get a slap on the wrist elsewhere could result in your motion being thrown out entirely. This judicial crucible has a profound effect on the lawyers who practice here. It burns away the ego. It forces a level of preparation that is almost pathological. New York lawyers don't just research the law, they research the judge. They pull up every decision that judge has ever written on a similar issue. They talk to other lawyers to learn their pet peeves. Does the judge hate long sentences? Do they prefer arguments grounded in policy or strict textual interpretation? You tailor your entire strategy not just to the law, but to the specific intellectual and temperamental profile of the one person in the room who matters. This creates a feedback loop. The judges are tough because the cases are complex and the lawyers are sharp. And the lawyers become sharper because the judges are so demanding. It's a legal ecosystem that self-selects for a certain type of personality. Incredibly resilient, hyperverbal, and comfortable with constant pressure and confrontation. You learn to think on your feet like nowhere else because you have to. When a judge interrupts you mid-sentence with a hypothetical question that completely undermines your entire position, you don't have 5 minutes to think. You have 5 seconds to respond, and your answer can determine the fate of a billion-dollar company. This is why a simple motion hearing in New York can feel like a Supreme Court argument somewhere else. The intellectual firepower in the room is immense. The stakes are astronomical, and the person wearing the black robe is not just an umpire. They are the gatekeeper, the inquisitor, and the ultimate arbiter of a system designed to handle the most complex disputes on planet Earth. They are a reflection of the city itself. Brilliant, impatient, and relentlessly demanding of excellence. And surviving them is just the first part of the battle, because then you have to turn your attention to the lawyer standing at the other lectern. And in New York, your opponent isn't just another lawyer. They're a product of the very same unforgiving fire. They've climbed the same greasy pole. They've survived the same academic gauntlets, aced the same soul-crushing exams, and impressed the same gatekeeping partners in a series of high-pressure interviews. They've pulled the same all-nighters, fueled by the same stale coffee and sheer ambition. When you look across the courtroom, the deposition table, or the boardroom, you're not just looking at an adversary, you're looking in a mirror. A slightly distorted, hostile mirror, but a mirror nonetheless. And that changes everything. In many legal markets across the country, there's a spectrum of talent. You might draw a case against a solo practitioner who's stretched too thin, or a lawyer who's just not at the top of their game. It happens. You can sometimes win a case not because your arguments were brilliant, but because your opponent simply made a critical mistake. In New York, that's a luxury you can't count on. The concentration of talent is so dense, the competition so fierce, that the baseline level of competence is extraordinarily high. It's like being a professional athlete where every single game is the championship final. There are no easy matches. There are no off nights. The lawyer on the other side is almost guaranteed to be smart, prepared, and backed by a team that is just as driven as yours. They won't miss a deadline. They won't misread a key statute. They won't be intimidated. This no weak links reality creates a unique kind of pressure. You can't just be good, you have to be flawless, because you can be certain your opponent is striving for the exact same thing. This baseline of excellence is then supercharged by a legal culture that is famously, and often brutally, aggressive. Lawyers in other cities talk about the sharp elbows of the New York bar. And it's not an exaggeration. It's a professional environment where confrontation isn't just accepted. It's often the default setting. This isn't about yelling and screaming, though that can happen. It's about a relentless, strategic, and unyielding assertiveness in every single interaction. Take, for example, something as simple as a discovery dispute. In a more collegial legal market, if you need a few extra documents from the other side, the process might start with a friendly phone call. "Hey Jim, just following up on our request for the Q3 financial reports. When can we expect those?" The lawyers might work it out, agree to a new deadline, and move on. In New York, that phone call might not even happen. If the documents are one day late, the first thing you receive might be a 10-page letter, saying the judge, detailing your alleged failures to comply with the rules, and threatening a motion to compel, complete with a request for sanctions. The very next day, that motion is filed. It's not personal, it's tactical. It's about creating a record of your non-compliance. It's about papering the file to make you look unreasonable to the judge. It's about driving up your client's costs and putting you on the defensive. This aggression permeates every facet of litigation. New York lawyers are masters of motion practice. They will file a motion to dismiss your case on day one, arguing that even if everything you allege is true, you still lose as a matter of law. Even if they know the motion has a small chance of success, they file it anyway. Why? Because it forces you to spend weeks and tens of thousands of dollars in client money responding to it. It delays the case. It tests your resolve. It's a war of attrition fought with paper, and the first battle is often just to keep your case alive. Then there are the depositions. A deposition is where lawyers get to question witnesses under oath before a trial. In some places, it's a relatively straightforward process of gathering facts. In New York, a high-stakes deposition is theater. Psychological warfare. The questioning lawyer will be surgical and relentless, trying to box the witness into a contradiction, to provoke an emotional response, to create a soundbite of testimony that can be used to destroy their credibility in front of a jury. The defending lawyer will be equally aggressive, lodging strategic objections not just to block a question, but to disrupt the questioner's rhythm, to signal to the witness how to answer, or to simply run out the clock. Every exchange is a chess move. Every word scrutinized for weakness. It's an exhausting, mentally draining exercise that can last for days, and it's a perfect microcosm of the New York legal mindset. Never give an inch. Compounding this is the sheer depth of specialization. The New York legal market is so massive and complex that it allows for a level of hyper-specialization that's rare elsewhere. You're not just up against a corporate lawyer. You're up against a lawyer who has spent their entire 25-year career doing one thing and one thing only: litigating hostile takeover disputes governed by the Williams Act. They know every single case, every obscure footnote in a law review article, and the personal preferences of every judge on the Delaware Court of Chancery. They've seen every argument you can make 100 times before. They have a playbook to counter your every move before you've even made it. This creates an intellectual arms race. You can't be a generalist and expect to survive. You have to go just as deep. You have to become an expert in your own niche, anticipating the obscure arguments your hyper-specialized opponent is going to make. The intellectual rigor required is immense. It's not enough to know the law. You have to know the law better than a handful of other people in the world who have also dedicated their lives to that same tiny sliver of legal doctrine. And your opponent is never just one person. They are the public face of a formidable, well-oiled machine. The big New York law firms are structured for total war. Behind that one partner at the lectern there is an army. A team of senior associates who have been working on the case for years. A bullpen of junior associates pulling all-nighters, sifting through millions of documents, checking every single citation in a 100-page brief. There are legions of paralegals, staff attorneys, and litigation support specialists. They have access to the world's top expert witnesses on speed dial, and a virtually bottomless budget for things like jury consultants and graphic designers to make their trial exhibits look better than yours. This machine operates 24/7. The pace it sets is relentless. If you serve a set of legal papers in the late afternoon, you're not just competing against the partner on the other side. You're competing against her entire team, who will happily cancel their dinner plans to tear your work apart and draft a response overnight. This relentless operational tempo is a weapon in itself. It's designed to overwhelm you, to exhaust you, to force a mistake from you or your team simply because you can't keep up with the sheer volume and pace of the work. This all contributes to the unwritten rules of engagement, the New York way. There's an expectation of blistering efficiency. Phone calls are brief and to the point. Emails are terse, often just a single sentence. There's little time for the social pleasantries that might soften legal practice in other cities. It's not about being rude. It's about the shared understanding that everyone's time is incredibly valuable, and there isn't a second to waste. For an outsider, this can feel abrasive and impersonal, but for New York lawyers, it's just the language of efficiency. In this environment, your professional reputation is your most valuable asset, and it is incredibly fragile. You are constantly being judged by your opponents. If you miss a deadline, if you write a sloppy brief, if you seem flustered in a conference with the judge, they notice. And they will use it. They will be less likely to grant you a professional courtesy, like an extension to file a response. They might subtly hint to the judge that you're not on top of your case. It's a high-stakes credibility game where one slip can permanently damage your standing in the eyes of your peers and the judiciary. This crucible of conflict, the hyper-talented opponent, the culture of aggression, the crushing institutional resources, is a defining feature of New York practice. It forges a very specific kind of lawyer, tough, resilient, precise, and perpetually on guard. But this entire adversarial ecosystem, this entire legal gladiator pit, is built on and fueled by one thing more than any other. It's the reason the talent flocks here, the reason the firms build their armies, and the reason every fight is a fight to the death. The sheer mind-boggling scale of what's at stake. Let's try to put that scale into perspective. In most American cities, a $100 million deal is a landmark event. It's the kind of transaction that gets the lead partners' names in the local business journal, merits a champagne toast, and becomes the centerpiece of the firm's marketing materials for the next 5 years. In New York City, a $100 million deal is a Tuesday morning. It's a routine piece of work for a mid-level associate. The rounding error on a single Manhattan merger and acquisition deal could fund the entire operational budget of a respectable law firm in Des Moines for a decade. We're not talking about a difference of degree, we're talking about a difference in reality. The financial stakes operate in a completely different language. When a lawyer in Chicago is litigating a breach of contract, the damages might be in the tens of millions, a figure that could cripple a regional company. When a lawyer at Wachtell or Sullivan and Cromwell in New York is litigating a similar case, say a busted merger agreement between two Fortune 50 giants, the number on the table isn't 10 million. It's 10 billion. That's a number with a B. It's a figure that doesn't just affect a company's quarterly earnings. It can alter the trajectory of an entire global industry. It can save or sink pension funds for hundreds of thousands of people. It's a sum of money that is, for all intents and purposes, an abstraction to most of humanity. But in New York, it's the job. This financial hyperreality changes the very DNA of the legal work. The due diligence isn't just thorough, It's pathologically exhaustive, because a single missed clause isn't a minor mistake, it's a potential 9-figure liability. The negotiations aren't just firm. They are gladiatorial contests of endurance and intellect that can stretch for days, fueled by caffeine and the knowledge that a single concession could be worth more than the GDP of a small island nation. Every move is magnified. Every word in a contract is scrutinized with the intensity of a bomb disposal expert, because the financial consequences of an error are simply too catastrophic to contemplate. This isn't just about getting the client a good outcome. It's about navigating a financial minefield where the mines are the size of city blocks. And the money is only the beginning of what's at stake. Because in New York, you're not just fighting over capital, you're fighting over the law itself. Tucked away in a stately courthouse in Lower Manhattan is the United States District Court for the Southern District of New York, known to lawyers everywhere simply as the SDNY. To the layperson, it's just another federal court. To the world of business and finance, it is the Coliseum. It is, without exaggeration, the most influential and powerful commercial trial court in the world. Why? Because it has jurisdiction over Wall Street. This means that nearly every major case of securities fraud, insider trading, complex financial crime, or corporate malfeasance of national importance lands right here. When the government decided to prosecute Bernie Madoff, it happened in the SDNY. When titans of the hedge fund world are accused of cheating the system, their fate is decided in the SDNY. When two global banks sue each other over a derivative swap gone wrong, the battle is fought in the SDNY. The judges in this court are considered the intellectual heavyweights of the federal judiciary, and their rulings don't just resolve a dispute between two parties. They send shockwaves through the entire legal and financial system. A decision made here on what constitutes insider information, or how a corporate bankruptcy should be handled, or the legality of a new financial instrument, becomes the de facto law of the land. Courts in California, Texas, and Illinois will cite SDNY opinions as persuasive authority. International firms in London and Hong Kong will adjust their practices based on a ruling from a judge on Pearl Street in Manhattan. So when a lawyer stands up to argue a motion in that courtroom, they are not just speaking for their client. They are speaking to an audience of the entire global financial community. They are arguing for a position that could redefine the rules of capitalism for years to come. The stakes are not just monetary. They are precedential. They are, in a very real sense, historical. A win isn't just a win for the client. It's a new brick in the edifice of American commercial law. A loss isn't just a financial setback. It's a legal precedent that could handicap companies in your client's industry for a generation. This combination of astronomical financial stakes and law-defining precedent creates a third, intensely personal, dimension of risk: reputation. New York is the undisputed media capital of the world. The Wall Street Journal, the New York Times, Bloomberg, Reuters, their headquarters are all within a few square miles of the courts and the big law firms. They have teams of specialist reporters whose only job is to cover high-stakes corporate litigation and deals. This means there is no such thing as a quiet big money case in New York. Every filing, every motion, every courtroom utterance is public record, and it's being watched. When you're a lawyer on one of these cases, your performance isn't just being judged by the partner you work for or the client you represent. It's being judged by the entire industry. Your name will be in the press. Your strategy will be dissected and debated by other top lawyers. Your reputation, which is the only real currency a lawyer has, is being forged or shattered in real time on a very public stage. In another city, a lawyer can build a solid reputation over 20 years of good, steady work. In New York, a 35-year-old litigation associate who delivers a brilliant oral argument in a major case can become a legal superstar overnight. They'll be poached by rival firms, courted by headhunters, and sought out by the world's most powerful CEOs. Conversely, a seasoned partner who makes a critical error in a multi-billion-dollar trial can see a lifetime of work evaporate. They become a cautionary tale. This constant, unforgiving scrutiny creates a pressure that is unimaginable to most people. It's the pressure of knowing that your every professional action is being recorded for a global audience. It's the difference between playing a pickup game in the park and playing quarterback in the Super Bowl. The field is the same size, but the consequences of every single play are magnified a million times over. The stakes aren't just about the client's money or the future of the law. They're about your own professional survival and legacy. It's a crucible that either forges you into steel or breaks you. And the reason all of this, the money, the precedent, the reputation, is concentrated here is because New York is the ultimate convergence point. It is a complexity engine. But what does that mean, a complexity engine? It's not just a buzzword. It's the fundamental operating system of New York law. It means that in any other major American city, a lawyer might become an expert in one specific high-stakes field. In Dallas, you might be the go-to expert for oil and gas litigation. In Los Angeles, you're the master of entertainment contracts. In D.C., you live and breathe federal regulatory law. You build your career on a single massive pillar of expertise. In New York, that's not enough. Here, the pillars aren't separate. They're a tangled concrete and rebar jungle fused together. The practice of law here is defined by the violent, chaotic, and brilliant intersection of world-altering industries. Take finance. We're not talking about helping a local business get a loan. We're talking about Wall Street, the financial capital of the world. A lawyer here isn't just drafting a loan agreement. They're structuring a synthetic collateralized debt obligation, a financial instrument so complex its own creators might struggle to explain it to a layperson. They are orchestrating $100 billion mergers and acquisitions where a single misplaced comma in a 1,000-page document could trigger a $10 billion lawsuit. They're navigating the arcane rules of the Securities and Exchange Commission for an initial public offering that will be scrutinized by every major investment bank on the planet. The level of abstraction, the sheer volume of capital, and the speed at which it moves creates a legal reality that feels like it's operating under a different set of physical laws. Then, crash that into international law. New York is home to the United Nations. It's a global center for international arbitration. So a dispute isn't just between two companies from different states. It's between a sovereign nation and a consortium of multinational corporations over the expropriation of a national resource. The legal framework isn't just the U.S. Code. It's a dizzying patchwork of bilateral investment treaties, the New York Convention, and the public policy of 3 different nations. The lawyer in that room has to be a diplomat as much as an advocate, understanding not just legal precedent but geopolitical tensions and cultural sensitivities that could derail the entire proceeding. A case in New York can literally affect a country's GDP or its relationship with the United States. Now let's smash real estate into the mix. New York City real estate is a world unto itself. We aren't talking about zoning variances for a new deck. We're talking about the legal alchemy of air rights, where you are literally buying and selling the empty space above a building. We're talking about deals that involve assembling dozens of individual parcels of land, each with its own century-old title issues, to build a new super-tall skyscraper. The legal battles fought over a few feet of Manhattan bedrock are more complex and more expensive than the battles for hundreds of acres anywhere else. The value is so concentrated that the law has evolved into this incredibly dense, almost Talmudic set of rules that only a handful of practitioners truly understand. And just when you think it can't get more complicated, you slam it all into the world of media, art, and intellectual property. This is the home of Broadway, of the world's biggest publishing houses, of global news conglomerates. The copyright and trademark cases that come out of the Southern District of New York don't just set precedent for the U.S. They set the global standard for what constitutes fair use in the digital age, for the future of streaming rights, for the very definition of artistic ownership. A lawsuit here can determine whether a new technology lives or dies, or how an entire generation consumes its culture. But here is the absolute key, the thing that truly separates New York from everywhere else. It's not just that all these hyper-complex fields exist in one place. It's that they are constantly, violently, and unpredictably colliding with each other. This is the cross-pollination effect, and it's what forces the evolution of a different kind of lawyer. Imagine this scenario, a scenario that happens every single day in a New York law firm. A Brazilian tech unicorn wants to go public on the NASDAQ. That's a finance problem, right? An IPO. But wait, their entire valuation is based on a portfolio of software patents. That's an intellectual property problem. And those patents are being challenged in a German court. Now it's an international litigation problem. To fund the pre-IPO expansion, they need to secure a massive new headquarters in Hudson Yards, which involves a fiendishly complex commercial lease and air rights negotiation. That's a New York real estate problem. And the company's founder is in the middle of a high-profile, contentious divorce, which could threaten his control of the company. Now you have a matrimonial law problem with implications for corporate governance. In any other city, this would be a case for 5 different siloed law firms. In New York, the expectation is that one firm, maybe even one core team of lawyers, can see the entire board. They have to understand how a ruling in a German patent court will affect the language in the SEC filings. and how the terms of the real estate lease could impact the company's valuation for the divorce settlement. You can't just be a specialist. You have to be a polymath. You have to be fluent in the languages of multiple legal and commercial worlds, and be able to translate between them in real time, under immense pressure. Your brain has to operate like a central processing unit, taking in data streams from wildly different sources and integrating them into a single coherent strategy. This relentless cross-pollination creates a legal environment that is exponentially more complex than the sum of its parts. It's a system of systems, and navigating it requires a different mindset. It's less about knowing the answer and more about knowing how to function when there is no clear answer, when precedent is being set by your very actions. This leads to another fundamental difference: the client. The nature of the work in New York attracts a client base that is, to put it mildly, the most demanding on earth. You are not advising a small business owner who is intimidated by the legal process. You are advising a hedge fund manager who has 3 PhDs and expects you to be smarter, faster, and more ruthless than they are. You are advising the general counsel of a global bank who is likely a top partner at a competing law firm and knows every trick in the book. You are advising an art collector who views a multi-million-dollar lawsuit as just another move in a game of chess against a rival. These clients don't pay you hundreds or often thousands of dollars an hour for you to simply recite the law. They can read the law themselves. They are paying for your judgment. They are paying for your strategic creativity. They are paying you to find a path to victory that they, with all their resources and intelligence, could not find on their own. The expectation is not legal counsel. It's business partnership. They want a consigliere. They want someone who understands their global risk profile, their competitive landscape, and their ultimate objective, and can then bend the massive, creaking machinery of the law to achieve it. The question is never, can we do this? The question is always, we are doing this. Tell us how. This transforms the lawyer-client relationship from a service provider to a strategic weapon. You are an integral part of their war room, and the pressure to deliver is astronomical because for these clients, second place is the same as last place. It's a total failure. And in New York, failure is not an option that is well tolerated. This intolerance for failure cultivates a work environment that is, to put it mildly, intense. It's a culture built on a single terrifying concept that governs every minute of every day: the billable hour. Now, lawyers everywhere track their time. It's how firms make money. But in New York, the billable hour isn't just a metric. It's a religion. It's the air you breathe and the ghost that haunts your sleep. The target at a top-tier NYC firm isn't a gentle suggestion. It's a hard floor. We're talking 2,000, 2,200, sometimes even 2,500 billable hours a year. Let's break down what that actually means, because the number itself is deceptively simple. A standard 40-hour work week, 50 weeks a year, gets you to 2,000 hours of work. But that's not billable hours. Billable hours are only the time you are actively, provably working on a client matter. The 20 minutes you spend talking to a colleague about a case strategy may be billable. The hour you spend on administrative tasks, firm training, or trying to fix your printer, not billable. The lunch you inhale at your desk, not billable. Getting coffee, definitely not billable. To actually bill 2,200 hours, you are likely physically in the office or logged in and working for closer to 3,000 hours. Do the math. That's not an 8-hour day. It's not even a 10-hour day. It's a 12-plus hour day every single weekday, with work bleeding into most weekends. It's a relentless minute-by-minute accounting of your existence, typically broken down into 6-minute increments. 0.1 on the timesheet. Every email, every phone call, every document review is a line item on a spreadsheet that determines your value to the firm. It's like being a professional athlete, but instead of points and assists, your stats are tenths of an hour, and they're being reviewed not by fans, but by partners who hold your entire career in their hands. In other cities, a slow month might be met with the casual, things will pick up. In New York, a slow month is a flashing red light on your personal performance dashboard. A sign of weakness, a reason to question your place on the team. This obsession with billable hours fuels another uniquely New York phenomenon: the culture of FaceTime. While the rest of the world has been debating the merits of remote work, many of New York's most powerful law firms have held a firm unwritten rule. You need to be seen. You need to be physically present. Why? Because the work is unpredictable and moves at the speed of light. A partner needs to be able to walk out of their office at 9 p.m., scan the bullpen of associate offices, and see bodies in chairs, ready to be deployed. It's a signal of commitment. It shows you're part of the machine, available at a moment's notice to jump on a grenade. Leaving the office at 6 p.m., even if your work is done, can feel like a walk of shame. It sends a message, whether intended or not, that your life outside the firm takes precedence. And in this world, the firm is supposed to be your life. This creates a psychological tether to the office that is hard to describe. You're never truly off the clock. Your BlackBerry, yes, many firms still swear by them for security, is a buzzing leash. Your mind is a constant loop of deadlines and client demands. Imagine this scenario, which plays out every single night across Midtown Manhattan. It's Friday. It's 7 p.m. You've been grinding for 60 hours already this week. Your friends are texting you. On our way to the bar in the East Village, see you there. You promised. You were looking forward to it all week. You're packing your bag, ready to escape. And then it happens. An email lands. The sender is a senior partner. The subject line contains one word: urgent. Your heart sinks into your stomach. You know what it means. Your Friday night is gone. Your Saturday is probably gone. Your Sunday is a maybe. You text your friends. So sorry, something came up at work. Rain check. They reply with an understanding, no worries. But you know, and they know that this is the 5th time this has happened. The rain checks are piling up, and eventually people just stop asking. This is the trade-off. It's the unspoken pact every New York BigLaw associate makes. You trade your time, your youth, your relationships, your hobbies for 2 things: unparalleled professional experience and an astronomical amount of money. And let's be clear, the money is a central character in this story. The salary scale for major law firms across the country, known as the Kravitz scale, is set by a New York firm. First-year associates, fresh out of law school at 25 years old, are starting at over $225,000 a year. Within a few years, with bonuses, they're clearing $300,000 for even $500,000. This compensation acts as a powerful set of golden handcuffs. The lifestyle it affords in a city as expensive as New York becomes addictive. The luxury apartment, the designer clothes, the dinners at Michelin-starred restaurants, the weekend trips to the Hamptons. It all becomes normal. And once it's normal, it's terrifyingly difficult to give up. You might be miserable, exhausted, and dreaming of opening a surf shop in Costa Rica. But when you look at your bank account and your mountain of student loan debt, the thought of walking away from that paycheck feels impossible. In other legal markets, say Minneapolis or Phoenix, the pay is still excellent, but the gap between that and a normal professional salary isn't as vast. The cost of living is lower. The golden handcuffs are a little looser, a little easier to slip out of if you decide the price is too high. In New York, they are welded shut. But it's not just about the money. The other side of that pact is the experience and, perhaps more importantly, the network. This is the secret currency of New York law. The people you are working alongside until 4 a.m. in a conference room littered with takeout containers are not just your colleagues. They are the future general counsels of Fortune 500 companies, future U.S. attorneys, future federal judges, future titans of private equity. The opposing counsel you're battling against isn't just some lawyer. They're a legend in their field, and by going toe-to-toe with them, you are earning a reputation that money can't buy. The density of this elite talent is simply unmatched. In Washington, D.C., you build a network of government and policy experts. In Los Angeles, it's the entertainment industry. In Silicon Valley, it's tech. In New York, it's all of them all at once, colliding in the same conference rooms and courtrooms. You could be working on a hostile takeover of a tech company, financed by a private equity firm, that has regulatory implications being debated in D.C., and involves intellectual property from a media conglomerate. You are at the absolute center of the universe. The connections you forge in that crucible are bonds of a different kind. They are your ticket to almost any future you can imagine. Want to go in-house at Google? Your former colleague is a director there. Want to clerk for a Supreme Court justice? The partner you work for writes the best recommendations. This network is a safety net and a launching pad, a lifelong asset that makes all the sacrifice feel, to many, like a strategic and worthwhile investment. It's this unique combination of crushing pressure and unparalleled opportunity that forges a very specific kind of lawyer, one who is conditioned to see every problem as a war to be won and every hour of their life as a resource to be deployed in that battle. And the battlefield where this war is waged is unlike any other in the nation, the New York court system itself. To understand the New York lawyer, you have to understand the arena they fight in. It's an ecosystem so dense, so fast, and so unforgiving that it fundamentally alters the practice of law. Forget what you've seen on television. Unless that show was about gladiators being thrown into a pit with 10 times the normal number of lions. First, let's talk about sheer, overwhelming volume. The New York State Unified Court System is one of the largest and busiest in the entire Western world. It handles millions of filings every single year. A single judge in a Manhattan courthouse might have a docket that's larger than the entire caseload of a small county in another state. This isn't just a quantitative difference, it's a qualitative one. There is no time for leisurely contemplation. There is no room for error. The machinery of justice in New York doesn't just move. It hurtles forward with the unstoppable momentum of a runaway subway train. This translates into a pace that would give lawyers elsewhere vertigo. The infamous New York Minute isn't a cliché in the legal world. It's a deadline. In many jurisdictions, asking a judge for a 2-week extension to file a brief is a routine, often granted request. In a high-stakes Manhattan court, asking for that same extension might be seen as a sign of weakness or worse, incompetence. The judge, juggling hundreds of other complex cases, doesn't have 2 weeks. They have 2 days. Maybe. The expectation is that you are always on, always prepared, and always ahead of the game. Delays don't just cost your client money. They clog a system that is already strained to its absolute limit, and the judges who run that system have no patience for it. You learn to work faster, think quicker, and sleep less, not because you want to, but because the system demands it for survival. But it's not just the speed, it's the specialization. New York City is home to some of the most sophisticated and specialized courts in the world, purpose-built to handle the city's unique legal diet of high finance and corporate warfare. Chief among them is the Commercial Division of the New York Supreme Court. This isn't your average state court. Established in 1995, the Commercial Division is an exclusive club for complex business disputes. We're talking about multi-billion-dollar merger disagreements, intricate shareholder lawsuits, and intellectual property battles between global titans. To even get your case heard here, the amount in controversy has to be substantial, $500,000 in Manhattan. The judges in the Commercial Division are not generalists. They are often former top-tier commercial litigators themselves, experts who have spent their entire careers navigating the very thickets of corporate law they now adjudicate. They speak the language of finance. They understand the nuances of a convertible debenture or a poison pill defense. You cannot walk into their courtroom and try to simplify the issues. They expect a level of sophistication and preparation from the lawyers that is, frankly, stratospheric. They've seen every argument, heard every excuse. Presenting a case before them is like defending your doctoral thesis to a panel of Nobel laureates who invented the subject. It is the big leagues, and if you're not prepared to play at that level, you will be utterly humiliated. Then you have the federal courts, and in New York, that conversation begins and ends with one legendary institution, the United States District Court for the Southern District of New York, or the SDNY. Located in downtown Manhattan, the SDNY is arguably the most influential and prestigious trial-level court in the entire country. Its jurisdiction covers Manhattan and the Bronx, which means it presides over Wall Street. For this reason, it has become the premier venue for the nation's most significant securities fraud cases, insider trading prosecutions, and complex white-collar criminal matters. It's so powerful and independent that lawyers and judges often refer to it half-jokingly as the Sovereign District of New York. This is the court that has handled landmark cases against financial giants, mob bosses, and international terrorists. Its alumni include Supreme Court justices and attorneys general. The prosecutors who work there, the assistant U.S. attorneys for the SDNY, are considered the absolute elite of the elite, recruited from the top of their classes at the best law schools, who then go on to become partners at major firms or titans of the judiciary. When the SDNY brings a case, the entire world pays attention. For a lawyer, litigating in the SDNY is like a musician playing Carnegie Hall. It is the pinnacle, a place where legal history is made, and where the pressure is so intense it can feel like the building itself is compressing you. This unique court structure, the lightning-fast state courts, the hyper-specialized commercial division, the powerful SDNY, creates a feedback loop. It attracts the most complex, highest-stakes cases in the world. To handle these cases, law firms must recruit the most ambitious and intelligent lawyers. And to survive in these courts, those lawyers must adopt a posture of relentless, unyielding aggression. The collegiality you might find at a county bar association in a smaller city is largely absent here. In New York litigation, your opponent is not your learned friend. They are the enemy. The objective is not to find a reasonable middle ground. It is to win. Decisively. This gives rise to what's known as scorched earth litigation. It's a strategy of overwhelming your opponent with sheer force. Buried in an avalanche of paperwork, dozens of depositions, an endless stream of motions designed not just to advance your legal argument, but to exhaust your opponent's resources and break their will to fight. It's a war of attrition, and in New York, the law firms have the armies to wage it. It's not necessarily pretty, and it's certainly not cheap, but it's a direct consequence of the environment. The system is adversarial by nature. New York just turns the dial up to 11, and the clients expect nothing less. A global investment bank facing $1 billion lawsuit from shareholders isn't hiring a New York law firm to be nice. They are paying those astronomical fees for a legal bazooka. They want lawyers who will fight for every inch, who will work through the night to find a fatal flaw in the other side's case, and who will walk into a courtroom radiating an aura of absolute, unshakable confidence. The client's demand for a warrior is met by a system that forges them. Lawyers who can't handle that pressure, or who lack that aggressive instinct, don't last long. They either burn out and leave the city, or they move to a quieter, less confrontational area of the law. The ones who remain are the ones who thrive in the crucible, who see a 2,000-page document review not as a chore, but as a hunt. This entire ecosystem, from the hyper-specialized courts to the battle-hardened lawyers, is fueled by one thing: an astronomical amount of money. The sheer financial gravity of New York law reshapes not just the city, but the entire world. And this gravity has a name. It's called the deal. Not just any deal. The multi-billion-dollar merger. The $100 billion acquisition. The initial public offering that births a new titan of industry. In other American cities, a $50 million lawsuit is a career-defining case that makes headlines. In New York, it's a Tuesday. Here, the numbers are so vast they become abstract, a string of zeros that represents the fate of global supply chains, the employment of tens of thousands of people, or the entire GDP of a small nation. This isn't an exaggeration. It's the daily reality of commercial litigation and transactional law in Manhattan. The legal work isn't just about the economy. It is the economy. It's the essential high-stakes architecture that allows global capitalism to function. And the architects, the lawyers, charge accordingly. This is where the concept of the billable hour transforms from a simple accounting method into something almost mythological. For the senior partners at the city's most elite firms, the rainmakers who command the respect of CEOs in foreign governments, the hourly rate can surpass $2,000, even $2,500. Let that sink in. A 15-minute phone call can cost more than a cross-country flight. An afternoon spent reviewing documents can cost more than a new car. A single week of a partner's dedicated time could fund a 4-year college education. This isn't just about paying for legal advice. It's about paying for access to a level of strategic thinking, influence, and sheer legal firepower that exists almost nowhere else on earth. You're not just hiring a lawyer. You're retaining a weapon. This financial stratosphere creates a gravitational pull that attracts the brightest minds from every top law school in the country. To lure them in, and to justify those partner billing rates, the firms have created a salary structure that is legendary in professional circles: the lockstep system. For decades, the top New York firms have moved in unison, setting a starting salary for first-year associates that is now well over $225,000. And that's before the bonus, which can tack on another $20,000, $30,000, or $50,000 in a good year. By their 4th or 5th year, these young lawyers are earning more than most surgeons. By their 8th year, as they approach partnership, their compensation can push into the high 6 figures or even 7 figures. This system, known as the Kravitz scale, after the firm that historically sets the bar, creates an intense, almost frantic competition. Law students aren't just competing for a job. They're competing for a ticket to a different economic reality. It's a world of immense privilege, but it comes at a staggering price, paid in time, sleep, and personal sacrifice. And it fundamentally warps the legal landscape. The sheer cost of hiring a top New York firm means that only certain clients can afford to play the game. This creates a chasm. On one side are the Fortune 500 companies, the investment banks, and the ultra-high net worth individuals who can write the checks. On the other side is everyone else. This financial reality gives birth to a specific, brutal form of legal combat: bet the company litigation. When a lawsuit threatens the very existence of a multi-billion-dollar enterprise, the budget for legal defense becomes effectively infinite. This is not about finding a reasonable settlement. This is total war. The goal is not just to win, but to crush the opposition through overwhelming force. A single case might have 50 lawyers assigned to it. The discovery process, where each side demands documents and information from the other, becomes a weapon of attrition. Teams of associates work around the clock in document review warehouses, sifting through millions of emails, memos, and financial records, billing hundreds of thousands of dollars a week just to find a single piece of evidence. The strategy is often to make the process so expensive, so exhausting, and so time-consuming that the other side simply runs out of money and is forced to surrender. It's a grim calculus where justice can be secondary to financial endurance. This environment rewards not just brilliance but stamina. It creates a culture where outworking your opponent is as important as outthinking them, and it drives an endless cycle. The high stakes justify the astronomical fees, and the astronomical fees fund the armies of lawyers needed to fight these wars of attrition, which in turn makes the stakes even higher. But the New York legal world isn't a monolith. Beneath the towering skyscrapers of big law exists a parallel universe of elite specialists known as boutique firms. These are smaller, leaner, and often more specialized than their giant counterparts. They are the legal equivalent of special forces. A firm might consist of only 20 lawyers, but they are the 20 best appellate litigators in the country. Or they are the undisputed masters of a niche area of bankruptcy law. These boutiques often charge even higher rates than big law because they aren't selling manpower. They're selling unparalleled expertise. When a major corporation loses a billion-dollar case and needs to launch a last-ditch appeal to the Supreme Court, they don't go to their usual 1,000-lawyer firm. They go to the boutique that has argued before the court 100 times. And then there is the other side of the city's soul. The public interest lawyers, the prosecutors in the district attorney's offices, the public defenders fighting for the indigent. These lawyers are often graduates of the very same elite law schools as their big law peers. They are just as intelligent, just as driven, and just as passionate, but they have made a fundamentally different choice. Instead of a $250,000 starting salary, they might earn $60,000 or $70,000. They work in cramped, underfunded offices, buried under caseloads that would be unthinkable in the corporate world. They are driven not by the billable hour, but by a sense of mission, to prosecute criminals, to defend the innocent, to fight for tenants facing eviction, or to protect the civil rights of the marginalized. This stark dichotomy creates one of the central tensions of the New York lawyer's identity. The path to immense wealth is clearly laid out, but it requires a specific kind of sacrifice. The path of public service offers a different kind of fulfillment, but it often means a lifetime of financial struggle, especially when saddled with six-figure student loan debt. This choice, or the ghost of the choice not taken, haunts many lawyers in the city. It's a constant reminder of the immense power of money to shape not just legal outcomes, but entire lives and careers. Ultimately, the financial engine of New York law doesn't just impact the city, it projects its power across the globe. When a German car manufacturer and a Japanese tech company decide to partner on a new venture, where do they write the contract? Very often, it's governed by New York law. When a sovereign wealth fund from the Middle East invests in a mining project in South America, the dispute resolution clause in their agreement will frequently designate the courts of the Southern District of New York as the venue. Why? Because the world's commercial giants trust the stability, predictability, and sophistication of New York's legal system more than any other. They know its courts are experienced in handling complex, high-value disputes, and that its body of case law provides a clear roadmap for business. This makes New York City the de facto courthouse for global capitalism. The rulings handed down in those lower Manhattan courtrooms don't just resolve a dispute between two parties. They set precedents that influence the flow of trillions of dollars in international trade and investment. The city's legal gravity is so strong, it pulls the entire world into its orbit. This relentless pressure, this fusion of incredible intellect and unimaginable sums of money, forges a legal culture that is as brilliant as it is brutal. It shapes lawyers into some of the most formidable professionals on the planet. But what is the human cost of living and breathing this rarefied, high-stakes air? What does it do to the people who dedicate their lives to navigating this system? The answer, for many, is a profound and often painful redefinition of self. The pressure cooker of New York City law doesn't just demand your time, it demands your identity. The first casualty is often the separation between work and life. In a city that famously never sleeps, the expectation is that its elite lawyers don't either. BlackBerries, then iPhones, became digital extensions of the office, buzzing on nightstands at dinner tables during children's school plays. The billable hour is a relentless, unforgiving master. Every 6 minutes of your day must be accounted for, categorized, and justified. This transforms time itself from a natural rhythm into a commodity to be carved up and sold. Sleep becomes a luxury. Hobbies become distant memories. Relationships are strained under the weight of canceled plans and perpetual exhaustion. One former associate at a top-tier firm described it as a low-grade fever of anxiety that never breaks. You're constantly on edge, waiting for the next email, the next urgent request, the next fire to put out. Your nervous system is perpetually in fight-or-flight mode. This leads to a well-documented and tragic crisis within the profession. Lawyers, particularly those in high-stress environments like New York, suffer from disproportionately high rates of depression, anxiety, and substance abuse. The culture often discourages showing any sign of weakness. Admitting you're struggling feels like admitting you can't handle the pressure, that you don't belong in the elite club you fought so hard to join. So the pain is internalized. The stress is medicated with alcohol at endless networking events, or with prescription drugs to stay awake longer, or to finally shut the brain off at night. The human cost is measured in broken marriages, estranged children, and a pervasive sense of emptiness despite the outward symbols of success: the corner office, the expensive suit, the view of Central Park. And this is where the most insidious trap of New York City law reveals itself: the golden handcuffs. By the time a young lawyer is a few years into their career at a major firm, they're likely making a salary that puts them in the top few percent of earners nationwide. They've taken on a mortgage for $1 million apartment. Their kids are in private schools that cost more than a college education. They've become accustomed to a certain lifestyle. The thought of leaving, of taking a massive pay cut to work a 9-to-5 job in a quieter city, becomes financially and psychologically terrifying. The job that is causing the misery is also the only thing that can fund the life they've built. They are trapped. They can see the bars of the cage, and they know those bars are forged from gold, but it is a cage nonetheless. This dynamic is more pronounced in New York than anywhere else because both the salaries and the cost of living are so astronomically high. The escape velocity required to break free is immense. So, if the cost is so high, why do they do it? Why do the brightest minds from the best law schools in the country flock to this meat grinder? For the same reason climbers are drawn to Everest or astronauts to the stars, because it is the ultimate challenge. It's not just about the money, though that is undeniably a powerful lure. It's about the intoxicating thrill of the game being played at the highest possible level. In New York, you're not just arguing a contract dispute. You're structuring the multi-billion-dollar merger that will reshape an entire industry. You're not just defending a client. You're litigating a landmark case that will be studied in law schools for generations. You are in the room where it happens. The intellectual horsepower in a single New York conference room can be staggering. You are surrounded by and competing against the absolute best. For a certain type of personality, that environment isn't a deterrent. It's an addiction. The adrenaline rush of closing a massive deal at 4 a.m. or winning a motion against a legendary litigator is a high that's hard to replicate anywhere else. There's also the undeniable prestige. To say, "I'm a lawyer in New York," carries a weight that no other city can match. It's a brand. It signifies intelligence, resilience, and a capacity for incredibly hard work. It opens doors globally. A lawyer forged in the crucible of a Manhattan firm is seen as having passed the ultimate professional stress test. They are courtroom-ready, boardroom-ready, and crisis-ready. This reputation becomes a core part of their identity, a badge of honor earned through sleep-deprived nights and sacrifice weekends. And for many, that validation is worth the price of admission. But perhaps the most noble reason is the potential for impact. Because New York is the nexus of global finance, media, and international relations, the legal work done here ripples across the world. A human rights lawyer working for an NGO in Manhattan can influence policy in developing nations. A prosecutor in the Southern District of New York can take down international crime syndicates. A corporate lawyer can help fund the next world-changing technology. The scale is simply different. The opportunity to be a part of something historic, something that genuinely matters on a global stage, is a powerful, motivating force that can make the personal sacrifices feel justified. So, what is the final verdict? Why is practicing law in New York City different? It's different because it is the most concentrated, high-stakes, and demanding legal ecosystem ever created. It's the convergence of unimaginable financial power, global influence, a relentless 24/7 work culture, and an unparalleled density of intellectual talent. It's a place where the professional highs are higher, the financial rewards are greater, and the personal lows are deeper than anywhere else on the planet. Practicing law in cities like Chicago, Los Angeles, or Houston is like being a professional athlete in a major league. Practicing law in New York City is like playing in the Super Bowl every single day. It demands a different level of preparation, a different kind of resilience, and a different set of sacrifices. It is a city that will push you to your absolute limits, and in doing so, it will reveal exactly who you are. It can be a place of incredible opportunity, of immense intellectual satisfaction, and profound impact. But it is also a place that can extract a heavy toll on the human spirit. It creates a unique breed of lawyer, brilliant, tenacious, and battle-hardened. A professional shaped by the singular, unforgiving, and magnificent pressure of the greatest city in the world.